Her research focuses on criminal procedure, substantive criminal law, as well as sexual offences. She was awarded her PhD in 2023, and her PhD focused on the adversarial nature of the criminal justice system and the impediments it poses to complainant participation in the criminal process. Professor Omar is going to be our conversation starter with her first presentation. So please, may you join us.
We're focusing on law and procedure. While South African does not want to apply efficacy, obviously bound by it, can't really understand the law. But when we run disciplinary, not the law of the country, it is justice. But it is important to understand the legal framework and to draw out lessons from what's working and not working in terms of that broader legal context, so that we can learn from those successes and failures and think about how we could do things better at UCT. Could you change the slide, please? So we'll take a quick look at the infrastructure of the system that criminal law operates under. First of all, it's important to note that criminal law is a mixture of Roman Dutch law and English law, as most of our law in South Africa is. The dominant ingredient, definitely English law. And over the years, we've taken on a particular South African flavor, a form of adversarialism that we apply now. So we're much more of a South African mixed masala, greedy of sorts, but the core tenets of adversarialism remain a common law English tradition. So what that means is that structurally, we're restricted to a two-party system. It's the state versus the accused person. And the state prosecutes on behalf of society as a whole. That's what we say, because we take the theoretical view that a harm to one is a harm to everyone. And so the complainant, the victim, doesn't prosecute themselves. It's important to note that the prosecutor, while prosecuting the case brought by the complainant, is not prosecuting on behalf of the complainant. He is on behalf of society or the state, more accurately, because there are even different interests if you think about what society needs versus what the state is trying to achieve sometimes. So bearing in mind who this is brought on behalf of is very important to understand some of the tensions when we think about the failures of the system to meet the expectations of complaints. Importantly, in adversarialism, the presiding officer, the magistrate or the judge, plays a passive role in conducting the criminal proceedings. So the presiding officer is supposed to remain at arm's length to the proceedings and shouldn't be actively involved in asking questions to witnesses or interrogating evidence unless it's for the purposes of clarity. The presiding officer is supposed to remain at arm's length to the proceedings and shouldn't be actively involved in asking questions to witnesses or interrogating evidence unless it's for the purposes of clarity. The presiding officer is supposed to remain at arm's length to the proceedings and shouldn't be actively involved in asking questions to witnesses or interrogating evidence unless it's for the purposes of clarity. one of the key features of adversarialism is that evidence must be admitted orally, and that sounds like, often that sounds like, well, obviously we've all watched court dramas. It's always played out in the courtroom, but there are systems in the world where evidence is not primarily conducted orally, and it might be done through the means of affidavits, expert reports, or just an assessment of real evidence that is brought before a court that isn't sitting like a courtroom like this, and kind of acting out the motions of a trial. So what's the thing about oral evidence is that everything has to be admitted into evidence through oral testimony, which means even things like written documents or real evidence, what we refer to as real evidence like weapons, for example, will only be admitted if there is a person that is able to testify as to the veracity or quality of that evidence. Right? So in sexual offense matters, it means that there's a lot of pressure on the complainant to present a good case. Very often there's very limited other evidence. Can you change the slide, please? Okay, so just very briefly, the legal framework that we're looking at is obviously the Constitution is the supreme governing law, and the Bill of Rights in particular lists important rights that are relevant to both the complainant and the accused. Just briefly, equality before the law in Section 9, dignity, Section 10, freedom and security of the person, Section 11, privacy, Section 14, access to information, Section 32, access to court, Section 34. There are also then in Section 35 rights that are specific to arrested, detained, and accused persons. So the Section 35 rights are specifically for people that are the accused in a system and are not available to complainants. Now, Section 33 of the Constitution deals with administrative action, and that's usually not relevant to criminal courts, but that's exactly the principles under which UCT's disciplinary processes must operate. That there must be just administrative action, a fair tribunal that is properly constituted, and hopefully we'll have some time to unpack exactly how that happens. There are also other pieces of legislation that are relevant. The Criminal Procedure Act regulates court procedures, so the order of proceedings, what type of evidence, who may speak when, rules obviously about bail and arrest and search and seizure, who can be in court, and other procedural issues. The Sexual Offences Act, which is often referred to as SORMA, and so if you hear me say SORMA, I'm referring to the Sexual Offences Act. That might just roll off my tongue sometimes unthinkingly. But SORMA is where you find the substantive criminal law related to sexual offences. It's where all the definitions are where the offences of rape and sexual assault and other sexual offences are criminalized. And that is, since 2007, included in a comprehensive piece of legislation. The Criminal Law Amendment Act contains the mandatory minimum sentencing guidelines, which may be relevant to certain sexual offences, including rape and sexual assault. And the Protection from Harassment Act provides remedies for people that are being harassed, including applying for a protection order, how those protection orders can be implemented, what kind of protection you can get, and the Act also refers specifically to sexual harassment as a form of harassment. That's the legislative framework. Because we are an adversarial tradition, a source of law in South Africa is also the common law. Common law refers to the development of law through court precedent. So each time a case comes before superior court, that court engages with the facts, engages with the law as it stands, and in applying it to those facts, creates reasoning that becomes in later cases. And so much of the meat of how the law is applied is to be found in the legal reasoning of judges, and not only in litigation. Okay, you can change the slide, please. Thank you. Okay, so this slide just lists some of the key sexual offenses. Obviously, not all of them. The SORMA is quite comprehensive in including a number of different sexual offenses and defining them accordingly. But there are a few points about the legal development of rape and sexual assault that I just want to briefly highlight. So, like I said, SORMA was only enacted in 2007. Before that, the offenses of rape and what used to be known as indecent assault were governed by the common law. And under the common law, rape was gender specific, which meant it could only be committed by a man against a woman and only included penile penetration of the vagina. Right? So it was specific as to perpetrator and victim, and it was specific as to instrument. And so now SORMA has developed and broadened these definitions. Well, it actually started happening before SORMA through key cases like Marcia, but since 2007, SORMA has been the governing piece of legislation. And the definition now is gender neutral, so anybody can be guilty of rape, anybody can be a victim of rape. And it also is not restricted to penetration of the vagina. I don't know if you want me to go into any further detail than that, but I think the broadening of how we think about sexual penetration and how we think of sexual violation as something that's not only just sexual intercourse, which is not what rape is, but that is how the common law used to think about it, is important because we need to acknowledge the deep psychological harm and the infringement of dignity of that comes with sexual violence. So it's important to note that when a member of UCT is charged with a sexual offense, and I put sexual offense in inverted commas, they are not being charged with the crime of rape, sexual assault, right? They are charged with breaching the code of conduct or the rules or policies that govern their employment or their status as student or contractor or whatever else at UCT, for conduct that meets the definition of an offense. Right? We as UCT cannot say you are charged with rape. Because this is not, because UCT doesn't have criminal jurisdiction, because we can't run a criminal court. It's important to understand that. Can you change the slide, please? Okay, so I just want to pause on consent for a second. Consent is the concept that gives me the most sleepless nights in my work, for sure, and I'm sure most other people that work in this area. Consent is a definitional element of rape and sexual assault. What that means is that we've defined the conduct as being criminal because it was unlawful and intentional, but importantly, because it was without consent. And the consequence of that is that we spend an enormous amount of time in criminal proceedings dealing with sexual offenses, arguing about whether it was obvious to the perpetrator the complainant was not, right? And that creates, okay, I'll come to that. So SORMA clarifies that consent means voluntary uncoerced consent, right? So submission is not enough to meet the definition of consent. And that coercion includes situations of threats of harm or force, um, an abuse of power, fraudulent misrepresentations, or where the victim can't consent because of a temporary or permanent impairment to their capacity to consent. So, for example, a minor under the age of 12 simply cannot consent to sexual conduct. A person who is severely intoxicated has a temporary impairment of their capacity and could not in that moment have consent. So SORMA clarifies the things that would immediately lead us to think that there was coercion, this was non-voluntary. But the problem with the definition of consent is that it leaves untouched the gray areas where myths and stereotypes are allowed to enter. So while we talk about SORMA as having made progress in developing how we think about consent, because it defines it as the absence of coercion, in actual fact, it has not changed how the courts and how lawyers and even the public engage about what consent means. So questions about whether the complainant actually said no, whether that no was obvious, whether there was foreplay, and whether that foreplay meant that the accused could reasonably have thought that there was consent, sexual conduct. The character evidence of the complainant is allowed to enter. So we end up back where we started, which is admitting all of these, in fact, irrelevant considerations when we talk about, because we've allowed consent to remain a definitional element. And this is also true in administrative tribunals. We sit with the same problems in relation to consent in disciplinary processes as we do in the criminal courts. Consent is an enduring problem. Okay, so there are a number of challenges that the criminal justice system poses. And they are varied, but I just want to highlight a few that I think are relevant for the discussions we are getting. So the complainant is, as I said at the beginning, is not a party to the proceedings. That's because the formal parties to the proceedings, the only parties to the proceedings, is the state, represented by the prosecutor, and the accused person. The complainant is just a witness. The most important witness, sure, but still only a witness to the proceedings. And as a witness, doesn't have a lot of control over the process. So once the National Prosecuting Authority decides to proceed with prosecution, much, if not all of the decision making is out of the hands of the complainant, right? And of course, we can debate whether that is the way it should be, that's the way it has to be, or whether there's something we can do about that. But for the moment, that's what it means. Now, the only real control the complainant has over the process is not to make a report in the first place. That is the only foolproof way to make sure that you can control what happens. But of course, we want complainants to come forward. We want to be able to deal with sexual offenses. That is a massive conundrum for a complainant who may want to retain their own agency, but simultaneously want to report it, and then they have to make that difficult. In a criminal case, the state bears the onus of proving the case beyond a reasonable doubt. And that's the same for all criminal offenses, but it creates particular complications in sexual offenses. Often there's a single witness, only the complainant. There's very limited legal evidence to rely on. Plus the prejudices, biases, myths, and stereotypes that complainants of sexual violence, women in particular, have to face in court. And this is exacerbated by the emphasis on oral evidence, because it means that the truth of the complainant's version is tested by how well they conduct themselves on the stand, how well they fared under cross-examination. And, any of us who've ever taken an oral exam, we all respond differently to the pressure of being asked questions, sometimes very aggressively. And your performance in that kind of situation might have very little to do with whether you're telling the truth. So the emphasis on oral evidence exacerbates the burden on the state. It exacerbates the secondary trauma that a complainant experiences during the process, and in any event might not take any further the truth-seeking function of the court. So we do have to think about how and why we use oral evidence in this way. I think it's also important to note how few cases get prosecuted, because we talk about the criminal justice system and we talk about wanting complainants to come forward. How can we make sure that complainants are not scared of coming forward and having victim safety rooms and all the infrastructure that we encourage reporting, and I'm not saying we shouldn't do that, but we usually only prosecute between 10 to 14% of cases. In a good year, it's 14%. In a bad year, it might be even closer to 8%. That's on rape cases. So, for example, in the 2021 reporting year, we prosecuted about 5,100 of 50,000 rape cases, right? And that's not, and then the number of successful guilty verdicts is an even smaller percentage of that amount. Now, obviously, we want guilty verdicts, but for those of us that work in the area, like the Women's Legal Center, we're much more concerned with how many cases are getting to court. Because if you look at the later annual reports from the NPA, the number of successful convictions has gone up. It's gone up to almost 75%, but the number of cases prosecuted has gone significantly down. So the NPA is playing with stats in that way, making it sound like the prosecution rate has improved over time, when actually they are just being far more selective about which cases they are taking to court. And that's a real problem. So when we think about justice in a trial, when we think about justice even in an administrative process, we need to always bear in mind that we are probably talking about only a percentage of cases. And that's important because we need to contextualize and put into perspective that there might be other avenues to explore where more people can get justice if it's not through these. Thanks. Okay, so I haven't been keeping track of time, but there are a few things that I think UCT can take forward. So first of all, we need to avoid trying to run administrative processes like mini criminal courts, right? That's not the mandate of an administrative tribunal. We're sitting here in a moot court, but an administrative tribunal is not a moot court. It's not a mock trial. It is supposed to be something quite different from the rigid adversarial two-party system that we have in our criminal courts. And Isaac, Professor Smythe, the former DVC, Loretta Ferris, and others, including myself, have put a lot of work into thinking about how we can fashion a process that empowers fairness and justice, that tries to move away from mimicking the you know, lawyers standing up in front of a judge and arguing their point and aggressively cross-examining a complainant. But it is really difficult because you still have lawyers participating in that system, lawyers who have been trained in an adversarial system. And you're now saying to them, I know you spend 6 out of 7 days of the week in a criminal court, but for this one day, you must be a different kind of lawyer. That's very, very difficult in practice to implement. So I think we also, because we have more flexibility in an administrative process, we should be thinking about how we can give complainants more agency in the process. And no one knows more than me how tricky that is, because this was the focus of my doctoral thesis, and I still don't have what I think is a very good answer to that question, although my supervisor disagrees, but you know, it is a hugely complex question. But I think we can think more creatively about how the complainant gives input into the decision making throughout the process. Since we're not a criminal court and therefore have that have more flexibility, although, like I said earlier, we are still bound by fair administrative action, but I think we have more room to think about how we address anonymous reports. And through the UCT electronic system, it's possible for a complainant to make a report anonymously. But it's very difficult to know what to do with that anonymous report other than reporting it for statistical purposes, right? And that is important. We need accurate statistics. But what responsibility does UCT have upon receiving an anonymous complaint to act on that, right? And that creates huge conflicts, obviously, because UCT has a responsibility not just to the complainant, but to everyone in the UCT community. And so UCT also needs to make sure that alleged perpetrators are protected, that they have access to resources and support. And so we can't simply act on that basis in a formal process. But we could think about what steps we could take towards investigation, for example, towards keeping proper records, so that we can start building better cases should the complainant ever want to take it forward in the future. It also, if we did that, it might help us with handling patterns of behavior, where we have repeated complaints against the same person over multiple years, but complainants that don't wish to pursue the matter. And that leaves UCT in quite a vulnerable position, because if we've got information that there's someone that is a risk to the university community, but we can't proceed with a formal disciplinary process because we don't have a complainant, we don't have a complaining witness, that makes it very difficult for UCT. But I think we still have opportunity to think creatively about what we can do with that information, so that we can create a safer campus environment and a community that actually says this stops now. Thank you.
Thank you very much. Thank you. Thank you for those insightful words. I think that really positions the conversation for today, right? Because it seems like there is just a particular journey that is carved for us through the various systems, and particularly through the criminal justice system. So as Jamila is pointing out, that's where we could perhaps put our focus on how we deal with reporting, collection of information, and also repeat offenders. Because if we then look at the 2022 GBV report, we had 138 cases and 98 respondents. So we really have to start looking and find a way to address repeat offenders. But we thank you so much for those insights. I'm going to wait until we have the panel discussion, and then I think we can speak together as a collective. So then I'm going to go to our next speaker. Our next speaker is Anne Isaac. And according to her bio, we know that Anne Isaac is our legal manager for the Special Tribunal for Sexual Misconduct at UCT. She gained experience as a criminal litigator at the South African criminal courts during her time as a prosecutor for the state with the NPA, where she litigated a wide range of criminal cases with a significant amount of time in the sexual offences courts. In 2010, she was appointed to UCT as the legal counsellor in legal services with oversight of the student disciplinary tribunals. In 2019, she was seconded by the then DBC to lead and to set up a special tribunal just dealing with sexual misconduct. As one of her main mandates was to draft new procedures for sexual misconduct disciplinary matters with a synergized process for both staff as well as students, which was a first for South African University. During that secondment, she was invited to join other institutions, the Africa Ends Sexual Harassment Initiative, the Berkeley Center for Comparative Law and Equality, and she's also the recipient of the VC's Excellence Award for Global Citizenship for countering GBV. As I said earlier, we call together, this conversation is around thought leaders, where we can stand shoulder to shoulder. I also acknowledge that Siam is in the room now. As academics that look through a particular lens, as civil society with a particular lens, as government with a particular lens, and then through multidisciplinary view of this problem, we should and we must get towards a process that is humanizing to someone who has experienced sexual harassment or any kind of sexual violation of any sexual nature. So with that introduction, I'm going to ask Anne to please join us. Thank you so much, Andrea, and colleagues.
So whenever I listen around the criminal processes, I sit there in my head, my mind is going, okay, my job is the opposite. And that is to ensure that we don't conduct a criminal case at administrative hearings internally. I think there are certain commonalities in terms of what Jamila has raised around challenges and what we should be looking at. Because essentially where the main, I think, commonality is, what are we dealing with? What type of evidence? So regardless of whether it's in a criminal space or in an administrative space, and I'll get to the differences in terms of our requirements for proving a case and taking a case through the process, is that, and this is something I feel like I've been talking about it forever, is when we deal with either a criminal case or an administrative case, the evidence of someone who has been physically violated is very different from someone coming to give evidence about committing plagiarism, cheating an exam, or someone who's had their pen stolen or their money stolen. It's a very different, not that those, there isn't trauma in cases of, other crimes like robbery, etc. But it's been very difficult convincing people that when we are dealing with sexual misconduct, sexual and gender-based violence cases, that the focus needs to be inquisitorial. It needs to be a process that does not create the anxiety that one feels in a criminal court. And so that is what we have tried to achieve at UCT. I'm very bad at using PowerPoint presentations because I get terribly distracted. But I think, Mr. Marshall, if you want to just put it up and we'll see how it goes. Okay, so just to keep some sort of track, today I didn't really want to go through, a very procedural presentation in terms of what we do at UCT. Suffice to say, what you've heard from Jamila, and her first slide said adversarial. The difference would be that what we do at UCT in the special tribunal that deals with sexual misconduct is inquisitorial. We worked very hard and we fought hard to have the word changed. Jamila and I were part of the team that had these conversations over the years, in that we did not want to, we wanted the process to change from the adversarial process into an inquisitorial process. Because interestingly enough, when I came to UCT and I was dealing with only student discipline cases at that stage, which included general misconduct, which means we were dealing with plagiarism, cheating an exam, somebody getting drunk, as well as rape and sexual assault. And it was all in this one disciplinary space. And it was adversarial. We had attorneys coming in representing respondents. Respondents are perpetrators who are now charged and before a panel. The respondents they had the right to representation, and if it was granted, we had attorneys coming in and cross-examining, which is what a criminal process requires, that a respondent, a person who is charged, the accused in court, is entitled to have their representative come into court and cross-examine a person who has been raped and violated. And so we found that attorneys were coming in and doing exactly that in our general misconduct in student cases. And as a person who had come from the criminal courts, and I had to do it was a big mind shift, that I'm dealing with students, I'm dealing with an administrative space. And it started to feel really uncomfortable, sitting there listening to attorneys cross-examine and completely damage a survivor. And sometimes they wouldn't even complete their evidence. So the conversations around how inappropriate that was started, I think, right from the beginning, 2010, 2011. And when Jamila, joined the faculty, there was also these conversations that we had. And as you can see from Jamila's presentation, the requirements in criminal court is not what's required at an administrative space. And yet we were actually dealing with sexual assault, rape, sexual harassment. We're taking these cases through, and it was a mirror to what was happening in court. And we started to feel really uncomfortable about this. And I remember one particular, I think that was the turning point for me in terms of me becoming more vocal about this, is there was one particular case in the general disciplinary for rape, went before a chairperson, the proctor at that stage, and the assessors. And I came out of there. Now, the standard of proving a case is basically a criminal court, the expectation is that a prosecutor will prove a case beyond reasonable doubt. In an administrative space, the obligation is to prove your case on a balance of probabilities. It's a lower test than proving a case beyond reasonable doubt. So when you're proving a case on a balance of probabilities, all we're really doing is saying which is the more likely version. And so we do not need forensic evidence, and we do not need the kind of information one would need in a criminal court to prove your case beyond reasonable doubt. We would obviously have to prove a case, but this is on a balance of probabilities. It's literally a 51-49 at the end of the day, which is the more likely version. But we were burdening this process, and we were burdening survivors in a process that was still not litigating, but the manner in which it was unfolding was really a criminal court. But in this particular case, I remember there was even a medical report. We spent months trying to get a doctor to come and speak to that report. And this in itself is a major problem, because in a criminal court, one would need that J88, which is a medical report when a person is examined after an incident. We don't need that, but we had asked for it because the panel actually required it. The doctor was like, I'm not coming to a university to give this evidence. I'm busy. I've got to go to criminal court to give this evidence. I'm not coming here. So the months of waiting for someone to come and speak, as Jamila said, someone has to come and give that evidence as to what's on that document, played against the complainant, and that was secondary victimization. But I came out of that hearing so confident, being a prosecutor in court. I came out of there, and I remember the then registrar asked me, so how did it go? And I was like, I proved this case beyond a reasonable doubt. And I was absolutely confident, only at the end to be completely blindsided with a not guilty. And that's because we were in a process that didn't even require that level of evidence. And even the people adjudicating on this, I truly believed, and I, to this day, looked at it over and over, and we had proven our case beyond reasonable doubt. So then the next question was, why would a panel arrive at that kind of decision? Because who was sitting on these panels? The staff assessor was an IT expert. What would be the understanding of gender-based violence? What would be the understanding of how you view evidence, for a rape case? This was a rape case. And it wasn't really, it was a systems fault in the sense that we had, as I said, when compiling the composition of the panels were academics, because we had plagiarism, cheating exams. So those were the panels that were sitting even for rape and other matters. And the difference now is that the special tribunal no longer operates in that manner. What we have since 2019 is a specific panel tribunal where the presiding officer is a legally qualified person, but who has training or background in sexual and gender-based violence. Assessors, so a staff assessor and a student assessor that sits on these panels, it is mandatory regardless of how experienced you are in gender-based, sexual and gender-based SGBV, you still have to have mandatory training every few months. And the reason we built this into the policy and the procedures is that there's always new things that we need to be aware of. So there's mandatory training. So now we have panels that have some background training experience around what they're actually adjudicating. And that makes a huge difference. Statistically, in the last few months, we took 10 matters through without all of the medical evidence. And we've had all 10 convictions because it's correctly managed in that space. We're not always going to get all convictions, but we are in keeping with the mandate to have a survivor-centered process. But I don't want to go into as much detail with that. So I want to talk about, so the background is, that's where we came from, and we got the spanking new special tribunal that we're all incredibly proud of. We've got survivor support from the OIC that assists in channeling and directing the case into the tribunal. We take over. We then, talk the complainant through in terms of giving evidence. Oh, the difference is we've also written into the procedures, as Jamila has said, oral evidence has to happen at court. The new process at the special tribunal, evidence can be taken through based on written statements, alternative means of giving evidence. We can also take a recording of the complainant giving the evidence and play the recording at the hearing, and the panel, as well as the respondent and representative, can ask questions, and those questions can be put to the complainant, not in the same room. It can even happen a day later. So there's a lot of alternatives in terms of how we are dealing with this, and we do not require a complainant to sit there and look at the perpetrator across from them at the table. So the differences in the adversarial process and moving into an inquisitorial process, which is sensitive to the needs of the survivor, a very survivor-centered process, is all in the policy and in our new procedures. So this should be a perfect system, right? No. So it's still not. We still have challenges. And so as we were going, we're very excited and seeing the difference in how we are managing this. And suddenly you're faced with new challenges. And so I want to talk about just that. So we do have a change in procedures. We have a specialized unit. We are very, very careful about a survivor-centered approach, all of the support. And the new procedures also give the survivor the right to have legal representation outside. However, that representation is limited to basically being present in the process and having regard to the rights of the complainant, and can engage with our evidence leader who does the actual presenting of the cases. So all of that is in place, and we're good to go. And so we had a very, very contentious, complex case right at the beginning in the special tribunal. Again, we thought that this was a case that we were going to get a conviction, and it was not guilty. And the report from that particular chairperson was so absurd. It was like the person was still sitting in court. And we realized that we got this perfect new space, and we were still dealing with challenges. So one aspect, there's lots of other challenges, but one of the more important ones that I've presented on previously, and I'm adding it into our mandatory training for panels who are adjudicating, and that is, how do you interpret trauma evidence? What is trauma evidence? Now, we have the OIC and all our role players talking about trauma, so we all understand the trauma. What I am now struggling with to start promoting and educating and training on is, how does a panel sitting and hearing a matter, and they have to make a decision as to whether someone is guilty or not, how do you interpret trauma evidence and what it should really look like? And I was sitting there and thinking, listening to the expectations, the unrealistic expectation that a survivor must come and give this perfect evidence, this everything, so that, because your evidence has to make sense in order for it to be credible and therefore acceptable for a conviction. That is not true. So I've entitled it Imperfect Evidence Makes Perfect Sense. So next slide. Sorry, I'm just going to take my jacket off. So as I said, the gaps in the system initially was that there was different procedures for staff and students. There were different procedures for past staff and academic staff. There was a lack of a gender-sensitive approach, lack of a unique or specialized experience. We had proctors and chairs, prosecutors or initiators in the system, assessors. The length of time to finalize cases was also a challenge. Next slide. All right, so general university disciplinary practices. Currently, most institutions deal with all types of misconduct in one disciplinary system for staff and one for students. Panel members and chairs may include academics with no knowledge or skill to deal with sexual misconduct. Process mirrors a criminal process. External legal representation leads to cross-examination. We've dealt with that. So next one. So when we looked at what was the objective of the university creating a specialized tribunal, it was to provide a disciplinary focus on GBV or sexual misconduct. So we're currently grappling with the gender-based cases that are not showing a link to sexual harassment. And we're currently in conversations about how do we fix this. Because when the policy and procedure was approved, it says special tribunal, sexual misconduct. And it's almost tied our hands in not being able to deal with any sort of case that is related to gender-based violence, but where it's not related to sexual harassment and sexual misconduct. But that's for another day. So we wanted to ensure that presiding officers and assessors were skilled and qualified to hear SGBV misconduct cases, reduce and fast-track old and new reported cases of the system,
reduce the time taken to initiate contact with the survivor, expedite preparation of witnesses for trial, develop alternative methods of leading evidence, which reduces secondary victimization, to provide specialized legal skills for best prosecution outcomes, to build capacity and resources in respect of tribunal members, to ensure that the procedural process is compliant with internal policies, external legislation, and policy obligations in synergy with the rights of the accused, and most importantly, responding to the survivor's needs as envisioned with a survivor-centered approach. Online tribunal performance surveys were done for survivors and other complainants as a monitoring and accountability tool.
And just to say that we actually synergized a process which was not easy, because remember, when you're dealing with staff matters, there's labor considerations and other laws that become applicable in terms of employee-employer relations. And so we had to make sure that in synergizing a process where whether you're staff or student, whether you're an academic, a professional or administrative staff member or a student, you're going to come to the same tribunal if you are in breach of the sexual misconduct rules. So a lot of work had to go into how do we ensure compliance with legislation and institutional human resources, policies, and procedures in order to achieve this.
So the legal framework, Department of Higher Education policy framework to address gender-based violence in personal education and training, and the codes of good practice on the handling of sexual harassment cases in the workplace, Employment Equity Act, the Labor Relations, Higher Education Acts, Promotion of Administrative Justice Acts, Promotion of Equality and Prevention of Unfair Discrimination Acts, and the national directives, and gazettes. We had to monitor the gazettes as well in relation to all the new
updated codes of good practice to ensure that we incorporated the necessary compliance into the processes.
So what's missing?
We've got all of this now, and what's missing in this
Judicial process.
We weren't seeing much
Connection
in bringing survivors into this inquisitorial process and thinking about what are we trying to do? Yes, reduce trauma, secondary victimization, help the survivor to go through this process without feeling anxious. I mean, there's always going to be anxiety, but to minimize that. There was an absence of social workers, talk therapists, current trauma therapy practices, GBV expertise, and explaining evidence from a trauma survivor, the impact of litigation and justice for the survivor. And where this became glaringly obvious is one of the cases I spoke about. It took almost a year because the respondent was legally represented. And whenever a respondent is legally represented at a hearing, we are overwhelmed with lengthy correspondence where they don't understand institutional laws, their policies. They don't understand administrative law. I mean, I've had attorneys come in and ask for an absolution from the instant. Everybody's like, okay, what is this? So they still use terminology that they use in a high court. And they don't understand that they're here in a higher education institution. And this is what, administratively, all we need to do is to have a process that is fair, it is reasonable, and complies with the elements of natural justice, and proving our case on a balance of probability. So the environment is still becoming so highly charged with that litigious nature of what attorneys do. And that we have to constantly remind everybody in the room, sorry, you're not allowed to do that. Chair, I object to this. And then you end up arguing because we have these litigators that are still in an administrative process and at the level that they are. And of course, a lot of chairpersons allow it to a certain extent simply because, and it's understandable, is that you also don't want to be seen to be limiting the rights of the respondent, because we have to be cognizant that a respondent has rights too. And so it's a very difficult space to manage, because you don't want to say, you don't ask that question, because it could actually have implications for the respondent in terms of the respondent's rights. So it's a really fine balance in terms of recognizing the rights of the respondent, but also helping the survivor go through this process in a survivor-centered way. And so in this particular case, the survivor had been seeing a psychologist and a trauma psychologist on her own personal time, outside. Now, not all survivors can afford that. Not everybody is going to go to a psychologist that's charging, fees at the level where they're doing all these new treatments in terms of, I always forget this, it's called EMDR, I think it's some eye movement desensitization sort of therapy that helps with trauma at this level. But in this hearing, just listening to them give their view on what a person experiences, the trauma, having them explain it to the panel and to everybody made such a big difference, because we are legal people. We can't have, the survivor support person is not a non-participant in the hearing because they're there to support the survivor. So we need to call an expert, but how do we call an expert who's not seen the survivor? So it's a very tricky space, but we should be hearing from experts on trauma in order to assist the adjudicating panel to make the right decisions in interpreting trauma evidence. Next slide. Okay, this was a case scenario. It's quite lengthy. This was for another presentation, so I'm not going to go through the entire case. Yeah. So next. So just quickly, questions that normally come from the complainant, that are asked to the complainant. Why did you not scream? I wanted to, I could not. Why did you spend the night with the respondent? I was shocked and scared. I trusted him. You continue to drink and party with the respondent. I don't know why. You can't be telling the truth if you can only remember some parts of your evidence. I am telling the truth. You're only telling us what is convenient for you. No, it did happen. I just can't remember all the details of what happened. It was a long time ago. It's hard to process. These are actual questions that were asked in different cases. I think because of time, can you just do the link, please? But based on these questions and answers, there's just a link that I could just ask for some indulgence of you to just to play this. I think it is on the next slide. Don't just use the link.
Maybe I should play it on
the link. Yeah. We're going to close this and on that. I think that Dr. Jim Hopper, who talks about the neurobiological reasons for why trauma evidence will not look perfect, explains the gap in the interpretation of trauma evidence. Hoping we can get there and just quickly listen to it.
May I make a suggestion? Maybe we could start a panel discussion with this. So with the links, with the video that we want to show. Okay?
what is the time?
Let us use this as a conversation starter for our panel discussion. Yes, we're going to use this as our conversation starter during the panel discussion, so that we can help you to play.
Yes. So in closing, just to, I think it was the critical point that I wanted to make was the last slide, is the kind of questions that are asked, the answers that are given, and how we're constantly confronted with, is the panel going to see, in essence, that trauma evidence has to be interpreted differently, and to what extent we need to start educating all role players in understanding, in addition to the legal aspects, the neurobiological trauma that plays out in evidence and how the evidence should be interpreted linked to that. Thanks.
Thank you. Thank you so much, Anne. Thank you for showing us the complexity from where the system came from, the historical background, and how we've arrived at this still imperfect system. But that kind of already positions a conversation of how then can we improve it in the next month, in the next year, in the next 10 years. So thank you very much for that. So now we're going to move on to our next speaker, who's graced us all the way from Johannesburg, Advocate Ntabiseng Sapanya Mohale. Ntabiseng holds a BA in social work originally, an LLB, as well as an LLM from the University of the Witwatersrand. She's currently a member of the Johannesburg Society of Advocates. She has extensive experience in working with survivors of sexual and domestic violence. She has held a number of several senior management positions in all spheres of government. Her focus has been mainly on constitutional and human rights, social justice, with a particular emphasis on gender equality, women empowerment, as well as racism. She's a commissioner for the Commission for Gender Equality, where she serves as the chairperson. Commissioner Sapanya Mohale also sits on the strategy planning, legal and complaints, and the finance committees of the CGE. Please, let's put our hand together for Advocate.
Before I get accused for misrepresentation, I have left the Johannesburg bar. I'm full-time at the CGE. And these days you can never make a mistake, lest you end up being on the front page on a Sunday morning. My presentation will basically be trying as much as possible to, I thought there would be a mixture of students and academics, but it's basically just trying to give a context to the kind is a bit of a wrong word. But the student who ends up, the most likely student who ends up at a university like yours, some of the experiences I took from mine, because as you heard, I started at Wits in 1982, raw from the township. So I've been battered in so many ways. So some of the things that students go through, I do know. I mean, we had to be carrying around dictionaries and, half the time you couldn't even find the word in the dictionary because the pronunciation was so foreign. Yeah, thank you for the invitation to be part of this important dialogue. Unfortunately, in South Africa, today we can never have enough dialogues to address the issue of challenges and best practices to deal with GBV in higher education, which is what the brief had said I should focus on. The issue of GBV in higher education is indeed a manifestation of the dynamics of the society we live in. The young men and women coming to these institutions are fully fledged members of their respective communities. They come to institutions such as these with an already set half-full template, if one could use that phrase, that needs to be augmented and enhanced to enable the young person to go into the bigger world and supposedly make a difference. We should always remember that university community is made up of individuals grouping together for a specific time-bound purpose, but coming from own communities that have already shaped and sharpened them. A good example is the fact that by age of 13, a person's language basis, including accent, has already been formed. So don't judge those people who've got a funny accent. It's by year 13, it's solid, it's there. By age 5, there are certain experiences that are permanently acting in the mind of a person, especially the exceptionally positive or negative ones. By exceptionally positive or negative, I mean experiences such as violence, loss of loved ones, disappointments, anxieties brought about by unceremonious relocation of families, rejections by others, etc. The experience of children is that when a parent goes to work and returns daily, they learn to adapt. When a parent is violent, they learn to adapt by thinking, I'm afraid of him or her, or I know they will not harm me, etc. That flight or fight survival mode that comes in. The biggest influence comes during the most difficult periods of puberty. I say the most difficult because this is when a lot of experiences are presented as a norm or a way of life. This is the most difficult time because this is the period when different forms of violence happen. Victimized parents open up about violence they experience, divorces of parents happen, emotional fear, all of those things, or feelings of not being good enough or to be loved take root during this time, as you almost probably know. Then there's the big shift. Coming to university, supposedly to be free, to enjoy life, to meet boys and girls, fall in love and be loved back, which hardly ever happens sometimes. If we can all look at our experiences, all those rascals we loved never loved us back. Basically finding yourself. It is also the scariest part of a young person's life. This is the time when that rucksack that you carried with your siblings, parents, and community member becomes your own individual baggage. Not coming from a wealthy family becomes even more burdensome. Not having some hip and branded items of clothing makes you feel exposed. You may not be, but you feel so. The materialistic university currency becomes torturous to some students. You know, I went to Students' Union once at Wits a few years ago. I was shocked to see that the Students' Union, where we used to eat pasta and mushroom sauce for I don't know how much, but it was dead cheap, has now got Steers, Nando's. You know, it's like, who can afford these? You know, but they were there, and I was wondering what then happens to those, I know engineering students, for example, used to eat at the, what's that, workers' restaurant, workers' canteen, that's what we call it, because they used to sell pap and a big piece of meat. And I was wondering, what then about that cohort of, workers' canteen students who cannot afford those branded foods. You know, there's also groupies, peer pressure, difficulty to cope with your studies, yet not everyone else around you seems not to be coping. You all know those students who are annoying, who pretend that they cope. In fact, I think I can accuse all of you in your PhDs that you are those students who make us feel like, how come everybody's coping and I'm not? You know, you lend friends, but they make you feel lesser than. Then bigger challenges start. The wrong boyfriends who are abusive, predatory lecturers who have, unbeknown to you, picked up your vulnerability for one reason or the other. Experiments with alcohol and other dependency-forming substances. The freedom I mentioned earlier, you think it comes in handy, but that is where the vulnerability is. Then the abuse in relationships, you recognize it, but sometimes you think it is a norm after all, depending on the family and community you come from. I'm not sure how many of you are actually aware of a practice, I don't want to say a culture, but a practice that has now been embedded in a culture where some people go to initiation school, and when they come back, they test drive their penises. I'm sorry to be so crude. They test drive their penises with the local young women in those communities. They call it uchisa ifuta. Each one of us here must actually be appalled, and we must all make sure that uchisa ifuta one day is a thing of the past. Young boys run amok in the communities. But the sad thing is the moms, aunts, and everybody just actually feel, oh, it has happened and everything is in order. Thank you, my son. Then life goes on. So those are some of the students that come to institutions like yours who actually think, violating somebody, how dare you even say no? And then you find that young girls who experienced the rape blame themselves for being in the wrong place at the wrong time. You've mentioned some of those where even the questions and the look that people are given is saying there must have been something wrong that you did. We all know the famous questions, what were you wearing? Did you drink? As though if you drink, you actually are asking to be violated. Where your drink gets spiked and you are getting raped, you feel dirty and not anyone tell anyone because you know there isn't even anyone to blame. You know, it's even more torturous to actually not even know who violated you. It's one thing to actually say it's so and so, but if you don't know, it's almost like don't start. You know, sometimes the violations are done by lecturers. You don't tell anyone because you went to their office uninvited and genuinely maybe going to ask about your work. In other instances, you discover your sexuality, you stay in the closet for fear of being judged, worse still, fear of being raped if you're a girl, and we know that happens in South Africa. So it's actually a very tumultuous time for the young boys and girls who you are teaching at this university. The question then is, whose duty is it then to understand all this? Simple. The institution that these students join have a duty. In this case, it will be the UCT. Fortunately, there's a very low progress in that regard. We still have lecturers who say they are there to teach, nothing more, nothing less. I did my LLB 1999, 2000, etc. I was at Power. I resigned there and then went to study. I thought, you know, let me do something better with my life. And there was a group of us as older students, you know, because we were like 34, 35, and you had these 18-year-olds who were annoying and they knew everything. But anyway, we had to deal with that. And one of our friends was going through a divorce. And one lecturer actually said, you know, you come to my office to ask for an extension, yet you are raising an adult problem in an institution for young boys and girls. We don't talk divorce here. Sorry, I can't help you. Your problem is strange and unique, you know, and it was so hurtful because now you realize the prejudice that institutions sometimes put into place to say, what problem should I bring to you? Should I actually say, but I've been sexually violated, or what, for you to actually think, okay, this is relevant. But the person was told, sorry, you're talking about problems that don't belong here. Others give it a racial slant and pretend they cannot relate. We all know that, especially in the 80s when I was at varsity, you had lecturers who say, I don't understand what you're talking about. But I must also confess we got away with murder because we told them about how the shack caught fire and I couldn't finish my assignment when you live in a proper brick and mortar house. And they fought it because all of them were in the suburbs then and they couldn't understand. So you live in a tin shack. Okay, no, let me give you an extra week to bring your assignment back, and you say, yes, God. Yet others give it a social explanation as to where they come from, and that issue does not occur. I have had young people who contact us at the CGE and say, I'm doing my master's and I'm going through 1, 2, 3, 4. And I have a lecturer who says, where I come from, that does not happen, or it wouldn't happen that way. So I can't help. Can I have my assignment, please? You know, so those are some of the excuses. And these would be maybe people not coming from South Africa and saying, I can't relate to that, sorry. It's the duty and responsibility of the institutions to be responsive to communities they serve. In more ways than one. For example, setting up of counseling and related support services. We know all that happens, and a lot of universities tend to think that's as far as they should go. That helps, I must say. I took my contraceptives at the Vets Campus Health Clinic. My parents did not even know I was doing that. So those things help, but it's way beyond that now. The dynamics and the challenges that the young students at universities are experiencing are totally different. Those services have got to be continuously reviewed in relation to impact, in relation particularly to the supposed beneficiaries. Is counseling always the relevant service that the university can provide when somebody has been violated? Should there be more? Those kinds of things that, have to be asked. Safety plans in universities, public consultation areas for students and lecturers. We went to do a spot check at one of the TVET colleges in the Free State, and it was shocking how the lecture halls were in one area and the residences and library were in another. And it was almost like you actually need transport to commute between those. And the institution was arguing that this is one institution. For years and years now, people have been working. And why we had to go was the complaints that we're getting about the attacks that students were getting there. So there's this issue of universities sometimes saying our core business is to teach, whereas the core business is to teach in an environment that is enabling for teaching to be efficient and effective. And those things have got to be looked at. So safety plans have got not only to be about the lighting and the doors that lock, etc., but when some of the students walk away from here and maybe they take transport to go to a back room in Khayelitsha because they did not get rest, they cannot afford rest, they cannot afford the fancy apartments around, where are they going? The universities have got to start asking themselves then to say, where are they going? Because contrary to popular belief, there are students who stay in back rooms in the townships. And we tend to associate institutions of higher learning as, no, they most probably must be here because they're very bright or their parents can afford. Therefore, they cannot be. You'll be surprised if maybe you check how many of them are actually at back rooms in those areas. And then we also need extensive investment in socio-political, economic induction of staff across the board. While the alienating culture stays in our higher education institutions because there isn't a common vision sold to staff in most cases, if it happens, is academically inclined. I'm not sure, maybe here I'm putting my foot in it, so please feel free to correct me, but I'm not sure how much of the induction of staff is about the kind of student who comes to that university. The kind of student who has over the years, since the ripe age of 13, violated a girl in the name of, I was test driving my machine, that's no deal. The kind of student who at 15 was most probably violated by that 13-year-old boy next door. The kind of student who has actually seen their mom being assaulted and maybe sometimes even killed finally by their dad, and they're told, Begamtanda, there's nothing we can do there. He really loved her. So something to that effect. So I'm not sure if how much of that level of social or sociological induction is done for the staff of universities, because then it would give a different understanding. And then also befitting and remedial and consequential interventions where violations occur. The basis of this must be zero tolerance. Recognize the need for a layered approach. By layered approach, I mean we cannot end up with institutions saying this is an institutional matter. Where a clear-cut crime has occurred, the cops have got to come in. We are the ones who stand up on pedestals and say, look at ESCOM. Why are those people not arrested? Yet the violations that happen behind our closed doors, we tend to actually say, no, this cannot happen. It's a university thing. Rape is a crime. Sexual harassment is a crime. Harassment generally, socially, is a crime. Why are universities still entertaining these crimes using their own measures with very, very low what can I say, low benchmarks in terms of repercussions. Because what then happens, I don't know what happens, maybe 3 months salaries, or people are asked to leave and then go and look for a job somewhere. I don't know what happens, but crimes have got to be dealt as crimes, nothing else, nothing more, you know. And I think with students, it's slightly different. I'm not sure how universities deal with student versus student, but I've been involved in staff versus student violations where the leaning is towards maybe let this person go, and then, you know, the problem will disappear. Regular revisiting of values and visions of the institution to check relevance. I'm glad I'm at UCT, and I take it for granted that UCT is more or less like VETS to a large extent. There tends to be this unwritten rule about this is how we do here. This is how, as President Ramaphosa always puts it, this is how our forebears, I don't know how he puts it, but he puts it in a very strange way. This is how our forebears have done it. There isn't that efficient evaluation of saying, in 2023, should we actually be still calling people based on color so that they come and make us look good? Or should we be, you know, all of those things? Is it not the time where people are supposed to be having different values and vision of the institution rather than that one of saying, how do we protect and maintain the 1900 values and vision? And then how do we manipulate here just so that that of 1900 is maintained? You know, so those are some of the things where universities need to actually start over a period, you know, a certain period to evaluate their vision and you know, invest beyond academic areas of the institution. We in Gauteng, for example, when your child goes to UCT, you say, no, the child can't go to UCT, there are a lot of drugs there. Cape Town people say, no, don't let your child go to Johannesburg, they will end up with the you know, because of the environment that these universities find themselves now. But how much of the universities or institutions are actually alive to those environments and are mitigating and protecting their students, not themselves, but the students who come to the institution, so that they are immune to some extent. It can never be 100%, but to some extent immune to the dangers that lurk out there. There's also the need to remove a few cultures, the vessels culture. When I went to, as I was saying, went to VETS for my LLB, there was one friend who had studied in the UK. And one day he said to me, why is it that here in South Africa, it's teachers versus the students? And I was like, what are you talking about? And she said, where I have studied up to master's level in the UK, the lecturers have got an interest in the students succeeding and succeeding well. And yet I find in South Africa, through my children and through my studies now, that it is a versus relationship. You know, you walk into a lecturer's office and it's like, what do you want? I know I changed the course that I loved, race and racism, because I was late with my assignment and my lecturer said, forget it. Either you change now, it's February, or zero. I had to run around and go and get some course that I didn't know and didn't like, because I was looking at a zero. And this is not about the lecturer telling me once, but I'd gone there for a full 2 weeks. And she was like, you're wasting your time. It's a zero, or look for something. I'm not going to entertain, you know, those kinds of things. So the versus culture that sometimes blocks communication. Also remove, this is a favor we're giving you attitude. I know even our parents sometimes tend to do that. I was an active state person. My parents used to sit me down and say, you're totally ungrateful to be running around with the police and doing all sorts of funny things. You don't know how lucky you are. But I find that even in our institutions, sometimes teachers versus students becomes You know, you're busy complaining. Do you know what institution you are at? Do you know the currency of your certificate after this? If I were you, I would actually be eternally grateful. You know, there's that's big. And you don't belong, but maybe, just maybe, you may make it. The faculties that are notorious, your engineering faculties, for example, medicine and law have become, for us, the normal people, the plebs. But engineering and all others still are those faculties where if you make it to fourth year, wow, you must be a genius. And everybody else is still a normal student. But for some, it's like you must be a genius to make it. You don't belong here, but just maybe you'll make it. Remove also the unwritten message in that very few of your people have made it. We will not be surprised if you don't make it. These are said in rolled over pronouncements sometimes by teachers where you won't understand it. Why don't you go and read it again instead of giving you the benefit of the doubt and actually taking you into confidence and teaching you? But it becomes, I'm not sure if you'll understand it, but hey, you know, maybe next year you'll catch up. So how then do we remove all of these, which are barriers and sometimes just own personal prejudices that both sides come with? Open communication between the institution and students. The culture of courtship by political parties has to be minimized. Like I said, I was hoping they were going to be students here or student leaders, because that's, for me, is one of the things that is compromising growth in higher education institutions, where the communication of any leadership is actually influenced and informed by the character of the leadership of the political parties, when it shouldn't be. Politics, yes, politics have got to be in every sector, but not party political nuances where, you know, you go and break chairs or you do things because, hey, I'm wearing a certain color overall or something. Learn from those who came before you, but choose from who and what to learn. I think there has been a breakdown in terms of role modeling of leadership. There is a vacuum there, and we need to enhance learning and lessons from our young people, but also to encourage them to learn in a particular way. My son's other name is Onkgopotse. I named him after Onkgopotse Tiro, and I'm always fascinated when I read the speech that Onkgopotse Tiro gave at the University of the North in 1974 when he was just a young man of 20 years. You will not believe that, you know, I mean, who is this 20-year-old who wrote this? You know, you read Steve Biko's, whether it's I write what I like or anything, yeah, or anything of that, what you call it, and you actually think, how old was he when he died? He already had written this, you know, so that is what I'm saying, not only to learn from those who have passed, but who those are would actually take us a long way. And thirdly, to be a torchbearer, not a first. We're too caught up in the culture of I'm first to this, I'm first to that. Those firsts become too arrogant and they fail us. They tend to become celebrities and not understand the mammoth task on their shoulders. So let's encourage each other to be torchbearers and not firsts. Be of service and not to be revered. Deal with own prejudices to overcome barriers. And dealing with own prejudices is actually a lifetime of learning. Let's be open to that, you know. And institutions to acknowledge their community context. Cape Town is gangland. We need to ask ourselves, what are we doing to make sure that those students in those communities can commute in and out without ducking bullets? What are we saying about Emmy Beale, who was just at the right place, by the way, Kaeli Chow somewhere with 2 fellow students, was just seen as white. 2 weeks ago, we had the taxi violence, and the newspapers were blatant, all of them saying, what is it, the orthopedic surgeon or somebody who died, took a wrong turn, you know, and so what kind of a country, what kind of a city, what kind of a society is this where one wrong turn can cost you your life? And when you look at the pictures of Cape Town is supposed to be a world-class city. You know, where are the institutions that form this world-class city where one wrong turn, you're gone in that city? Will be marooned in that city, you don't go to these places or whatever. What happens if I get lost? One wrong turn, my life, something is not right. And those are the questions that we should be asking. Translating values and vision, as I said, to policies and implement, monitor, review, and audit. It's one thing to have a value base, it's one thing to have a vision, but at all times we need to audit that vision. Is it still relevant, as I pointed out? Do we need to review it, monitor it? When we say we are, I don't know what the vision of what you call it is. I know the VET slogan says VET gives you the edge, and we always laugh about it. You know, do I have the edge in terms of me as a professional, where I am a professional? What does it mean VET gives you the edge? You one step ahead of everybody in what sense? Is it in the right ways that you carry yourself, or it comes with the arrogance of saying, I'm a VETSI, etc. You know, those kinds of things. So those are some of the things. I know that's not the vision, but I was just making an example. These audits will actually help to reflect and influence the future, because institutions of higher learning are supposed to be centers of learning, actually. And then basically, just in conclusion, to say provide administrative justice. Justice for who? Justice for all of us. Because if we provide justice to the one person, I am a beneficiary of that person getting administrative justice. And administrative justice is kept up quite nicely in our Constitution. It's section 7.2, where it says the state must respect, promote, and protect the rights in the Bill of Rights. And I know when it says state, sometimes we tend to. So we tend to think government, but I think state is a whole lot. And then institutions like us, like these, we look at that. 9.3, the equality clause breakdown. Can I find myself in that breakdown? Can I find myself in that case? If not, how then are we continuing to teach our students and making them that it is all-encompassing? Who is missing from it? Section 10, human dignity. Is my teaching, is my learning enhancing the next person's human dignity? And of course, section 29.2, right to progressively realizable education that takes into consideration equity, practicability, and the need to redress. Thank you very much.
Advocate, thank you very much for educating us and reminding us that, you know, it's not really about the well